Okay, so good afternoon, students. I'll just start from the beginning since the recording started. So this is a class of professional practice law and ethics. I'll continue from module 4, lecture number 2. Okay, so this module 4 is related to the dispute resolution. Okay, so in somehow in particular a project where multiple clients or multiple parties may be joined together for a common goal or a common achievement, so there may be a dispute or conflict of interest, whatever you say. So to resolve that particular dispute between the multiple party or between two party, there should be a standard procedure how to solve a particular conflict between two or multiple parties. Okay, for that this alternative dispute resolutions or arbitration conciliation will come in picture. The main purpose of this arbitration, conciliation, and ADR is to resolve or solve the problem between a two party which having a common goal in a particular, uh, maybe involved in a particular construction or any other company. Okay, so it's a general term. This arbitration, conciliation, and ADR. It's a general term. And about that arbitration, it is already mentioned by ma'am in the last class, or you can say the first class of fourth module. So I'll just continue from the second module. Okay, sorry, second class. Okay. So wait a second. Let me first share my screen. I guess I hope my screen is visible to you. So here I'll just start my model 4 lecture 2. Try to take it as a very simple manner. You say, okay. So there might be some very complicated term will be there. Okay, but the general definition or general concept is very simple. Try to get the basic definition. Okay, so whatever I'm going to present to you, it's look like little bit lengthy. It's having a 6 page of notes. Okay, but if you see carefully, it's a very simple thing. Fine, and you can also read it out by yourself only. But yeah, I can understand there's some more complicated or some tough English word will be included here. It's need time to understand that, but yeah, it's very simple to understand, but you need to give some time for that. And it's not like a mathematical term, only simple thing that you need to understand. Okay, and always take it very easily. Don't go for any confusion. Okay, so here in this topic, lecture number 2 of model 4, that we are discussing about dispute resolution. Okay, or resolution, alternative dispute resolution, or arbitration or conciliation, all these things. Related to that, this lecture 2 is all about this particular model law. Okay, and it is, and simply we can say uncitral model law. UNCITRAL. Okay, so it's a capital word. UNCITRAL. I think you can see here. Okay, so what is the full form of this particular law? It is actually a subsidiary body of a United Nation. Okay, so it is a international. It's a organization of international level. And what is the full form of the particular law? United Nations Commission on International Trade Law. Okay, that means whatever uh, trade or any other deal or any other construction or any development on international forum or even in a national forum. Okay, whatever this construction or any other different types of transportation of goods or transportation of information, all these that international relation should be have some this support of this particular model law, that is UNCITRAL, for solving that international dispute. Okay, Okay, someone is waiting here. Fine. So I'll just go through reading the particular basic definition of this particular law. So United Nations Commission on International Trade Law, in short, UNCITRAL, is a subsidiary body. Subsidiary means added body, okay, or a separate body, you can say. It's a set subsidiary body of the General Assembly of United Nations. Fine. So what is the purpose of that particular this body? It plays an important role in improving the legal framework for international trade. Okay, the main purpose is to solve some legal conflict. Okay, between two country or between two state, like that. Okay, so it plays an important role in improving the legal framework for international trade by preparing how can they solve that legal conflict by preparing international legislative text and non-legislative text. Okay, there are two types of legal frameworks are there exist. Okay, so it plays an important role in improving the legal framework for international trade by preparing international legislative text for used by states in modernizing the law of international trade. Okay, so to for the improvement of the law related to international trade, okay, there is a existence of legislative text. Okay, international legislative text, and also there also one non-legislative text also be there for the use by the commercial parties in negotiating transaction. Okay, is there some conflict between two parties related to commercial or a negotiation transaction? Okay, for that a non-legislative text will be come in picture. Fine. This model or this subsidiary body, this legislative text addresses, okay, this particular legislative text of that this particular law, this addresses international sales of good. Okay, I'm just going through some important aspect that is included under legislative text. Okay, fine. So legislative text address international sales of goods, international commercial disputes resolutions, and then yeah, it includes both arbitration and conciliation. I think for regarding arbitration and conciliation, it is already known to you. Okay, anything anyway. If I want to repeat these things, what is arbitration? It is already given in the last class, I guess, by ma'am. So arbitration is what? It is a private process. Okay, it is not a legal or any state funding or that process. It's a private process. Arbitration is a private process where disputing parties, that means in which and those parties between which some disputes will come, some conflict of interest will arise. Okay, the disputed parties agrees that one or several individuals can make a decision about a dispute after receiving evidence or hearing arguments. Okay, that's why arbitration is a platform. Okay, arbitration is a private platform where without going for the legal aspect, without going for the legal aspect, it's a private process or private platform where two parties can solve their problem. Okay, in general definition, they can solve the problem privately. Okay, for that they can appoint a neutral panel or neutral committee which decides or which actually gives some judgment on a particular um, conflict. Fine. So arbitration is known as a private process where disputing parties agrees that one or several individuals can make a decision about a dispute after receiving evidence and hearing argument. Fine. And what is conciliation? I think this is also similar almost. Okay. So conciliation means what? So it's like a action of stopping someone. being angry. That means consolation means what? It's like consolation is a it's action which is which is done to stop the argument or stop the violence in a particular in two parties which are in a conflict. Okay, that means in a simple definition, what is conciliation? It is the action of stopping someone from being angry. Simple is that. Okay, so for that also there are some standard procedure how this arbitration and conciliation will done. This is the thing. Okay, so these all are included in the legislative text of this particular UNCITRAL model law, which is a subsidiary body of General Assembly of United Nations. Okay, okay. Along with this arbitration and conciliation, then others like e-commerce, like electronic commerce, all these things also involved in this uh, legislative text. Okay, then insolvency, including cross-border insolvency. Insolvency means if some party fail to provide payment for a particular thing or something. Okay, for that particular issue also be raised in a or particular these things insolvency also come under legislative text. International transaction of goods, international payment, procurement or infrastructures, security, interest, development, all these things will come under legislative text. Under non-legislative text, it includes actually rules. They are actually that describes non-legislative text actually describe what they describe rules for conduct of arbitration and conciliation process. That means how to do that particular process, how to go for arbitration, how the conciliation process will be conducted. Okay, these all things are under non-legislative text, like notes on organizing and conducting arbitral proceeding, how the proceeding will be go on, when the proceeding will be go on. Okay, all the legal guides on industrial construction contracts or contracts or counter trades, all these things, legal notice. Okay, all the details procedure proceeding. Okay, so all these things will be summarized in non-legislative text. Okay, so this is the basic difference between legislative and non-legislative texts which are actually included on this particular model law. Okay, that is United Nations Commission on International Trade Law. Fine. So this is basic idea about your international model, this particular model law. Okay, for now you just need to know these things only. Along with this, some additional information also given here about commercial arbitration. Okay, here some in total 9 articles are summarized in these notes. You can also go through each and every article. It's a part of that particular this model law. Okay, you can also go through this. I don't want to go in very detail. You just want go through the basics idea about how many articles are there. Okay, for now I've just given here total 9 articles. Okay, here you can see. So here in the first article, I'm just going to summarize here. In the first article of this particular model law, it represents that this particular law, this particular model law, is applied between two states. Okay, fine. As per some articles, which is already given in a particular law. Okay, and it is accepted by this United Nations Commission on International Trade Law on what? On 21 June 1985. You have to remember this. Okay, and this particular law can be used internationally. Okay, this law or this arbitration can be international, can be used as an international if the particular company are located and on different countries. Okay, then only that can be that there is also a provision to solve the international dispute. Okay, as per this particular article 1 2. Okay, because there is an amendment in 2006, that is one this article 1 has been amended by the commission. Okay, in 2006, and by this law can be utilized as an international law. Okay, fine. Yeah, all these things are already also given. I don't want to go through the every details here. How on Article 2, basic definitions and rule of interpretations are given. That means what is arbitration means, okay, what is court means, what is tribunal means. These things are very simple thing. You can also go through this. Arbitration already we already discussed about that in the last class. Also, ma'am also discussed with you. Arbitration is it's a private process where two parties agree to solve a particular problem, okay, privately, okay, on a separate platform. Arbitral tribunal is what? It is a panel which is selected by mutually by two parties. Finally, they decide. This arbitral tribunal finally they decide a judgment. Okay, fine. There is also one amendment is there, Article 2A. Okay, it's it's given some international origin and general principles. Okay, very two principles are given. You can also go through this. Receipt or retain a commission. This is also not that important, but you can also go through this. Waiver or right to object. This Article 4. Article 5 is your extent of court intervention. And yeah, finally, arbitration agreement. Okay, here also some definitions are given for arbitration agreement. Okay, so if I go by definition given in that particular law, so arbitration agreement is what? It's a agreement given by the two parties. Okay, given by the parties which are in a conflict. Arbitration agreement is a agreement by the parties to submit to arbitration all or certain disputes which have arises and which may arise between them in respect of a defined legal relationship, whether it may be contractual or not. Fine. So it's a basic definition are also given in Article 7. Okay, some may ask you in some question that about arbitration agreement, the definition are under which article? So the answer will be Article 7 like that. Okay. Arbitration agreement shall be in a written. So all very few important things are given here. Okay. There are lots of things that are there. Since a beginner, no need to go in very details. Okay. And finally here definition of arbitration agreement again. It's a optional things. Okay. Different definitions are given. I think all almost similar things are given here. Article 7. Now, Article 8, arbitration agreement and substantive claim before court. You can also go to the court if you're not satisfied with a particular arbitration. And finally, that arbitration agreement and interim measures by court. So here, very small, short things are given here. Okay, you can also go through these basic definitions. Fine, but I advise you to at least go through the basic background of this model that I have already discussed with you. Okay, these things, and you can also go through this particular different article. Total 9 articles are given here. Okay, it's not like that only 9 articles are there. There are lots of articles that will be there, but for now, you can also go through this basic idea about so that you can have a basic idea about that particular law. Okay, okay. So this is all about today class. So in this class, we discuss about that particular this law of United Nations, which is known as United Nations Commission on International Trade Law. Okay, which is act as a body to solve international dispute or even in the national level dispute also between two parties. Fine. So here I want to stop my sharing here. Wait. Okay, fine. Wait for some time. Okay, I'll just then I'll just take the attendance now, okay? Respond to our call then. Okay, wait. Respond to our call. Roll number 69. Roll number 51. 51. 52.
Present, sir.
53. 54. 55. 56. 57.
Yes, sir. 57.
Okay, 58. Okay, I also provide this PDF, okay? I'll provide this PDF to you, any one of you. Please share. Fine. 58, 59, 60, 61,
Present, sir.
62,
61 present, sir.
61 dead here, 61 dead here, 62, 63,
Yes, sir. 63.
64, 60, 65, 66,
Yes, sir.
67, 68,
68.
68, ठीक है. 69 absent ना. 70,
Present, sir.
71, 72, 73.
73.
Okay. 74.
Present, sir.
ठीक है. 75,
Present, sir. 25.
76,
Present, sir.
77, 78,
Sir. 25, sir.
78,
हाँ?
yes, sir.
75, 76, 77 है क्या? 77, 78,
Yes, sir. 78.
79, 80,
Present, sir.
81,
Present, sir. 81.
82,
Present, sir. 82.
83,
Present, sir. 83.
84,
Present, sir.
85,
Yes, sir. 85.
85 है?
Yes, sir. 85.
Okay. 86, 62, ठीक है. 86, 87,
Yes, sir.
88,
Yes, sir.
67, 89, 89, 90,
90 present, sir.
ठीक है. 91, 92, 93, present. 94, 91, ठीक है. 94, 95,
Yes, sir.
ठीक है 96 97
97 is present, sir.
98 99 100 101 102 103 104 105
Yes, sir.
okay 106 97 97 given है वो
Sir, 107.
okay given एक second 107
This is the top result.
98 sorry 100 107 108 109
Present,
110
sir.
109 ठीक है 110
Present, sir.
110 111 112 113 112 ठीक है given 113 92 given है 113 114 115 116 117 118
Present, sir.
119 18 ठीक है
Sir,
119
117.
okay 17 119
Present, sir.
119
Yes, sir.
okay 20 120
Yes, sir. Yes, sir.
okay 121 नहीं है ना टोटल हो गया 35 let's see ठीक है anyone left to give attendance who have given the attendance you can leave the class thank you
Sir, 72.
Sir, 94.
okay one by one 72 wait
Sir, 72.
okay given next
Sir, 94.
94 given already given I'll just
107.